advising clients across the country. Here he is, your host, J. Christopher Boyd.
Welcome back to Something More with Chris Boyd. I'm Chris Boyd, certified financial planner practitioner, and my office is Asset Management Resources. We're a registered investment advisor firm, and our show is a financial show. We like to talk about all manner of financial planning topics, personal finance and so forth, a little bit outside finance, but we're talking about estate planning today. I've got with me not only Jeff Perry, investment advisory representative with Asset Management Resources, but our guest, Attorney F. Keats Boyd, who is the principal at Boyd & Boyd, the law firm Boyd & Boyd.
Thanks for having me again. It's nice to be back.
Good to have you back. It's been a while.
Yeah.
Seems like it's been a long while.
It's, a vacation and life gets in the way, and who knows. Anyway.
Yeah, glad to hear it. Thanks for being with us. So we had been talking recently in a segment about life insurance and mortality.
Mm-hmm.
And so
everyone's favorite subject, by the way.
Yeah, it's fun stuff. We're a cheery crowd here. So I thought we'd talk about more death and dying. No,
let's add taxes to the mix just for fun. Right?
There you go. There you go.
Yeah.
Everyone's favorite subject.
Sure.
So in all seriousness, wanted to maybe just touch base on some estate planning elements of this kind of mindset, also part of the planning that, again, not that we expect to die anytime immediately, that kind of thing. But as Jeff said previously, we all know it's going to happen. It's not a question of if.
Guaranteed.
Two certainties,
Guaranteed.
Right?
Death and taxes.
So
we can get an extension for taxes.
Yeah.
Can't figure out how to get the extension on death.
We're still working on that.
Haven't found that yet.
Good medical counsel.
Right.
So one of the things that we were hoping to maybe just talk sort of a broad range of things, including a little bit about some of the basics of estate planning, and then maybe some of the application, because we've run into people who have family members, parents,
Right.
and they're dealing with some of the pragmatic realities of having to deal with, people who are going through decline and stepping in to sort of help them handle these things.
Right.
And having the right planning in place can make a big difference.
Makes a huge difference. It really does.
So that's kind of our arc of what we had in mind over the next half hour. So in any case, where should we begin?
Well, let's start with like the core.
Some of the
what's
basics,
the basic things that people should have as a part of their plan? Really, that revolves around a handful of basic documents that really hit all the basic goals that people have. Passing wealth at death, incapacity care planning, probate avoidance generally is among the goals, tax reduction, and sometimes asset protection. And your core documents for those goals really revolve around things like a healthcare proxy for making medical decisions. If you can't do that, some states prefer a living will. So it's a good idea to have both. No matter where you are, you'll have the document preferred in that jurisdiction. You might need to have a power of attorney or a durable power of attorney, one that will allow somebody to manage your finances if you can't do it for yourself, if you're incapacitated. Usually we want to have a will as a minimum, but we prefer personally in our firm the revocable trust as the means of passing wealth at death. So you want to have at least those basic documents as a part of the plan. And you really need to understand that certain documents handle certain timelines, if you will. The power of attorney and the healthcare proxy, those are documents that are used while you're alive, but perhaps you're incapacitated.
Mm-hmm.
Then there's documents that work with death, the will, the trust. The trust can also work for incapacity care planning. So it really depends a little bit on what we're trying to do as to which document's going to control that circumstance. Things that you leave in your name alone for financial assets, those will be governed by a power of attorney. Things you put into your trust, those will be governed by the trust if you become incapacitated. Things that are going to be managed at your death will again depend on how it's owned. Jointly held property passes by operation of law. Things with beneficiary designations or pay on death designations pass by contract to the beneficiary. Things owned by a trust will be governed by the trust. Things you own in your name will go through your will, but that usually requires probate, and it's a little more dragged out to get through that process. So, a lot will depend on what we're talking about as to how we achieve the particular goal that the person has. If it's managing assets during incapacity, that's usually going to be the power of attorney in the trust. If it's managing them after a death, that's usually going to be the will and the trust. So,
Keats, can I ask you a kind of a,
yeah,
maybe an odd question that you don't hear much, but it's certainly when people come in to have their estate plan, they're dedicated, they realize they have to do something, it's time to get these things together, and they're thinking about where their assets go and such. But what's your kind of advice when people say, oh, okay, I need a healthcare proxy, this power of attorney, durable power of attorney sounds good. Who should it be? Right.
yeah, right.
Because
That's
people,
a really good question.
yeah,
A lot depends on circumstance. We tend to see most of these documents go to family members as the agent. Again, it depends a little bit on which document we're talking about. So for the healthcare proxy, if you have a family member or somebody that you love or trust to make this decision for you, it's helpful if they have some background in medical decision making or medical info, so they can analyze the information that a doctor might provide to know what the consequences are. Not required, but it might be helpful. If you have a doctor or a nurse in the family, they might make a good choice for that. The other thing is geography.
right.
Very often these decisions need to be made very quickly. And if somebody feels like they have to travel from across the country to get here to talk to the doctor to see and make the decision, that adds a lot of time delay in that may not be practical. So sometimes having somebody who's nearby is helpful. Ultimately, though, you want someone who is going to understand what your thoughts are on, with the healthcare proxy, end of life decisions. Who knows what your thoughts are, who understands those thoughts, and can apply the facts and circumstances on the ground to what your general wishes are, and make sure that we're going to follow those wishes. If it's, hey, make me comfortable if I'm terminal, but don't artificially extend my life. You want to be able to have somebody who says, yep, that's what I'm going to do. On the other hand, if you have the thought of, gee, I really, I'm not ready to pass. Take every
death is forever.
and I'm not there yet. So take all reasonable approaches to keep me alive. You don't want somebody who's going to say, yeah, I'm just going to pull the plug. You want to get that warm, fuzzy feeling back from them to know that they're going to do what you want.
What your wishes were.
Yeah.
It's funny. I had a friend in high school that his mother was not well at one point in time, and seriously ill. And they were thinking, well, it's maybe time, and that was his, death is forever,
Mhm.
let's make sure we've done every possible thing,
Right,
that was what
right,
she
right.
wanted, that kind of thing.
Well, I know in our personal sense, I hope Mom won't be upset with me, but in our family, I'm not the healthcare guy, because I'm the guy who will find the moth in the closet, capture in my hands and take him outside and fly free, go away and live your life.
I'm the guy who'd capture the moth in my hands and, not really, but it is funny that there is that. I guess I'm thought to be a little more cold and heartless,
a little more pragmatic, not cold and heartless, pragmatic. And I'm the eternal optimist. Well, you're saying there's a chance. Right?
Yeah, right. Yeah, that was a great. What's that video? Dumb and Dumber.
Dumb and Dumber. Yeah.
You're saying there's a chance,
right?
Yeah.
Anyway.
Yeah, that's right. That's right. So you want someone who's aligned with what you'd want to be.
Right.
That kind of mindset.
And you have to have those discussions with that family member. Don't just name the person as your healthcare proxy in this discussion and say, I guess they'll see it when they need it. I mean,
yeah, you want to know in advance. You want to have that conversation, and as I said, get that warm, fuzzy feeling. They're going to do what you want, not necessarily what they would want.
Right. And it doesn't have to be the same person for the healthcare proxy as the power of attorney.
Exactly, because the power of attorney is a financial document.
Right.
Generally speaking, with a trust-based estate plan, and most of the plans that we prepare, for people who have a net worth over a couple $100,000 are going to be revocable trust-based estate plans. The only thing the power of attorney is going to handle will be maybe the day-to-day bank account, but significantly retirement accounts, IRAs, 401ks, 403bs, those can have significant assets in them. And so you need somebody who has some idea on how to manage those assets and deal with the financial planner and have that relationship with the advisor to make sure that the plan's working the right way. So it's a more of a financial skill set that's needed than the medical skill set that's required on the healthcare proxy.
How about for those individuals who don't have family members, either maybe don't have family members or don't have family members that they feel suitable for these roles?
That's usually a very difficult situation. I tend to say you don't necessarily want to name your attorney, which often comes up, well, can you serve in
Right.
that role?
Yeah.
And we'll generally discourage that because we're probably a little more distant. We're in the day-to-day rat race of running the law firm. We may not know exactly what your situation is or what your needs are. While we can handle the financial side, it tends not to be affordable in many cases. It runs up the cost because we're going to be charging by the hour for the time involved in paying your bills and doing that kind of stuff. And while we can do that, it may be better to have someone else involved who's a friend or a family member. If you don't have the family member, I often have clients who will look to a very close friend. Most people will pick their spouse as their first choice if they're married, but then look to usually one of the kids. And very often when these needs of urgency come up, the kids actually step up, much to sometimes mom and dad's surprise. This one will never be able to handle it. And yet here they are at the time of urgency. And we may end up having to jump through hoops to get them the authority to do these things, to get the person who's named to maybe agree to resign because maybe they don't want to serve, and then find a way to appoint the person who's actually going to do the job. Very often that can be done if the documents are built the right way with that flexibility in them. Sometimes you can't. You're stuck with what's in the document. And if you don't have the right backup person or a path to create a new backup person that may not be named in the document, then you're forced to go to court to have a conservatorship for the financial side or a guardianship on the personal medical decision-making side, none of which are really desirable because now you're in a court proceeding. While we've got a great court system in our country, it's generally a public system, meaning it's general information available to the public. You lose some sense of privacy. It's known in the court documents, and those often are public records, that you have an incapacity. And a lot of people don't want that to be out there. And so trying to build documents that give you flexibility, keep it private, is, I think, a better course of action than the other, going through the court proceedings.
Those proceedings are not inexpensive.
Right. Yeah. A power of attorney, if it's going to be an expensive, longer lasting power of attorney, sometimes will cost the estate. Last time I heard was about 8% of the value of the estate, where if you're going through a guardianship or a conservatorship, the cost to the estate itself can be quite significant. I've seen a figure of 50%, but I've not tried to go back and verify that source. So, you don't want to lose half the assets because you're going through a court proceeding where you have to account annually to the court and put in all the financial documents as to, what money was spent, what was it spent on, what income was received. That's, again, you don't want your personal financial situation necessarily in the court records. And so, but because it's a court proceeding, lawyers are involved, and that tends to get more expensive. So
let's talk about a practical scenario. Recently, I had a call last weekend from the daughter of a client who had been hospitalized, appears to be in cognitive decline, and she's trying to solve his care, his finances. A little bit overwhelming.
Yeah.
And she lives on the other side of the country, as an example, but came to visit, and kind of this all unfolded. I don't know if she came before or after, but you get my point.
Yeah.
Sometimes people are dealing with issues remotely, is where I'm going with this. And let's just talk about the practical, what documents in that little scenario that one would want to have in place.
All right. Well, again, it's the healthcare proxy for medical decision-making. That's critical, so that somebody has the authority to talk to the doctor. HIPPA authorizations. HIPAA is the law that says a doctor can't release your medical information without your permission. you want to sign a HIPAA authorization so that your healthcare proxy, your power of attorney, your successor trustees, all of
They
those
can get what
people
they need.
can have access to medical records to do the things they need to do, maybe to show that you are in fact incapacitated and that they need to come on to take over for you. Maybe it's so that they can get medical records because you were in a car accident, you're incapacitated, and they need the medical records to fight the legal battle. So HIPAA authorization is critical to be a part of your estate planning documents.
Something you don't necessarily think about.
Most people don't think about it. A lot of people don't even include it as a part of the estate plan, but it's a critical document. It's a very, it's a relatively short document, but without it, your family ends up having to go to court to get a court to authorize the doctor to release.
So it's more legal costs in the process. So the healthcare proxy for the health decision making. Now that's in Massachusetts. That's relevant.
That's right. Other states have a similar document called a medical power of attorney, where you appoint an agent to make medical decisions. About half the states in the country prefer something called a living will. Now, a living will basically is written instruction from you saying that here's the care that I want. Massachusetts doesn't recognize living wills, at least not yet. We probably will by court decision at some point, but right now we don't. But it does serve as kind of a written instruction, a guidance to your healthcare agent to say, don't give me this, do give me that. I think it's important that if you're going to have both documents, as we give in an estate plan, that there's a pecking order set between the two documents. So in our case, we say the healthcare proxy's decision will override what might be written in the living will. Think back to COVID when it first hit, New York and Los Angeles had really bad outbreaks in both places. And a lot of people had to be put on intubators to recover. Now, most living wills would say, don't intubate me. And so if you're in a living will jurisdiction, you're in a coma because of COVID and the doctor wants to intubate you.
I get that. The idea that I think there's some validity to the appeal of saying, I trust their judgment.
That's right.
I want that person's judgment to be as opposed to
black and white,
my finite set of facts that maybe things change and I don't know what
are going to be. And so the healthcare proxy, we make that the priority so that that person can take into account those unusual circumstances. Maybe that's me being the optimistic, save the moth guy. But, you want to be able to take that decision and say, in this case, it's curative. It's not artificially extending life. We want to be able to intubate. And I think a healthcare agent has a better person to do that. So we say the healthcare proxy has higher authority over the living will, even if they contradict one another.
Keith, can you add a little color on when the healthcare proxy actually becomes operative?
Yeah.
Because I think some people, when they're signing it as a client, if you would be making these decisions, maybe gets a little worried, like, well, I still get to make the decisions, right?
Right. And the answer to that, at least in Massachusetts, is yes, absolutely. If you can communicate your decision to the physician, it's your decision. It's really when you cannot communicate the decision, that's when the healthcare proxy kicks in to have somebody make that decision for you.
And do you outline definitionally what that means?
Well,
when you're preparing the document.
Yeah, it just means that there's no way for you to not really in the document, but from background, we know that means if there's no way for you to tell the doctor what kind of care you want, verbally, in writing, blinking your eyes, yes or no, whatever it is, if there's no way for you to communicate to the doctor, then that's when the healthcare proxy is going to step in and make those decisions for you.
And sometimes this gets a little bit more complicated. I was involved with a case that it was a cognitive issue where, an elderly person thought they could make their own decisions, but that it was in dispute.
Right. And that can end up in court, but technically, if you can communicate, my last case law that I saw was then that's the decision that will govern. Even though the healthcare proxy may say that's not in your best interest, then they'd need to go to court, have a guardianship appointment. And as the healthcare agent, they would have the authority to be the person nominated as the guardian to take over for those medical decision-making if you are in fact incompetent. But that would require a court finding to that.
Right.
So going back to my, scenario of daughter trying to take care of dad, going through health, changing health dynamics, and in this case, introducing cognitive component to it. So you've kind of addressed, hey, we really need these healthcare documents, the
Right.
HIPAA, the
Mhm.
Healthcare Proxy, maybe in other jurisdictions, slightly different
Right.
names and
Right.
design, but
Those
something
are
along
the
those lines.
core. Yeah.
And then there becomes issues of how do we pay the bills?
Right.
How do we make arrangements for selling a property, perhaps to be able to go to a nursing home? These
Right.
kind of
Right.
changing
So
dynamics.
those things will come from both the power of attorney and a revocable trust. So a lot will depend on what the
Structure, the existing estate plan.
yeah, exactly, whatever that has been executed up to that point. And if you don't have anything, then yes, you're going to need a conservatorship, a court proceeding to have the authority to sell the house and
Yeah,
trade
in
the
this case,
stocks and pay the bills.
this scenario that's sort of based on, that I'm basing this on, is slightly different from what I've shared, but you get the gist that. But they had power of attorneys established. That I think there was some, it was going to be. They had some documents, I guess.
Right.
What I'm driving.
As long as they have some documents, then the power of attorney will give the agent named in the power of attorney document the authority to handle things that are owned by the incapacitated person in their name alone.
Mm-hmm.
It doesn't handle joint property necessarily, although it usually handles real estate that might be jointly owned.
Okay.
But
and you mentioned earlier things like transfer on death and things like that that are contract assets in a sense.
Right.
But in this case,
if they're individually owned with the beneficiary designation on, the power of attorney is going to be the person with the authority to manage those.
Yeah.
Now, the power of attorney's authority ends when they learn of the person's death, of the principal's passing. And so a lot of people think, well, even though they've died, I can still do things under the power of attorney. And no, their authority has ended. They cannot. That's when the will kicks in, and we need to get a will,
a different appointment,
to admit it to the probate court and get an appointment, and then they can start doing things under the authority that the will would grant from to a personal representative. If you have things owned in a revocable trust, the successor trustees step up to manage and take care of things and pay the bills. And most people, if they're following the advice that we give, would have their home in the trust, their savings vehicles in the trust, money market CDs, that type of thing. Then brokerage accounts that are non-retirement brokerage accounts would be owned by the trust. So those assets would be governed by the trustee, and they'll decide how to handle those
which
things.
may or may not be the same as the power of attorney.
Right. Very often they are, but it depends on how the plan's structured. I think the bottom line is, if you are the child or the nominated person in charge for someone who is starting to have some incapacity issues, it's best that you try to talk to the attorney who designed the plan. Or if you don't know that person or not comfortable with those person, to find your own attorney to give you guidance. We have something where we call this type of situation a living administration. When people pass away, we have the death administration settling somebody's affairs. But they're very similar process to go through when there's an incapacity. We have to inventory what's out there. We have to decide how it's owned. Is it individually, jointly owned? Because that's going to dictate how who has the authority to manage those things. We have to maybe determine what things are worth at that time, not because we have, anything more than to understand what is the nature of the size of the estate. We're going to have to take the incapacitated person's name off and put on the power of attorney or put on the successor trustee, so they have authority with the institutions to manage those assets. We will need to file annual income tax returns. We got to make sure we have the authority to do that. That's usually in the power of attorney. So, and then we have to just manage the estate on an ongoing basis. So that 5-step process is really true, when there's somebody living who we have to settle the affairs in a sense. And we do it again when someone passes, and there's different ramifications for both. One of the things that we have available for our clients is a manual that's called a trustee manual, and it covers what happens if there's an incapacity for a married couple or for a single person. What happens if there's a death? How do you handle things, and what are the requirements, and what are the steps to do? What are the traps for the unwary? It's one of those things that's just a quick and easy guide, a frame of reference that is intended to help keep people on the right path and avoid falling into trouble with the other family members
Yeah.
or somebody else who might say, well, wait a second, what do you mean you sold the house for X many dollars? I wanted that house. You had no right to sell it.
Yeah.
It keeps you out of trouble by making sure people are properly informed and you're being transparent and those kinds of things that often are required.
Lots of prevention kind of thing. Yeah.
Exactly.
And now that's interesting. You mentioned that one of the things we talked about last week was the idea of, I think we mentioned family meetings.
Mm-hmm.
And I have generally avoided family meetings just because you just think so much can go wrong. There's an anxiety around it. I like the idea of having, communication.
Yeah.
But, different families have different dynamics.
Right.
What's your thought about that?
I'm a little mixed. I find that when a client has developed an estate plan, it's often better to say, hey, there's a plan. This is the attorney who's going to help the family through this.
Mm-hmm.
These are the people that are going to be in charge.
Like, give them the basics. Here's what I've planned, and this is my choice.
Right.
Like, as the parent kind of thing in this scenario.
And so we'll often do what I call a meet and greet with the family. The kids are here on the Cape for the summer. You want to get a half an hour of my
That's
time.
A good idea.
We'll give the broad brush strokes.
I think there's value.
What the estate plan is and who's going to be in charge and what does that job entail and that type of thing. I think when the parent is saying, hey, I want you to know who I've brought in, who my advisors are.
Yeah.
Right.
And they want to have that and they're saying to us, we understand that we want them involved, the child, the adult child. All good. I'm totally fine with that. It's just the unknown dynamic that, we're going to have a meeting. We're going to tell everyone what's the plan. And
then somebody says, but wait a second, why is he in charge? Not me.
Right. And then where they start questioning it. It's one thing where the parent's saying, this is what I've done.
Yeah.
And I just want you to be informed.
Right.
That's easier than why, all that kind of stuff.
Yeah. I think, another important thing that many attorneys have overlooked is something that's in our uniform probate code that I think can help protect family members when there's an incapacity issue. Sometimes a child, well-meaning, will bring mom or dad to the attorney and say, hey, this is what we want to have happen. Let's change things around.
Yes.
I should be the guy in charge. I should be,
because I'm the one who's here. I'm the one doing
who
things.
Inherits more because I'm the one who's doing things.
Yeah.
And that can be a real problem. And so I think it's important while mom and dad have the ability to, that they create something called a contract to will or a contract to plan. It's an agreement that basically says mom and dad each say, I'll give everything to you, you give everything to me, and we both agree to give it in the following percentages to our kids or to whoever the heirs are. And this is great for families that are in their only marriage or families that are in second or third marriages to make sure we're just setting out the rules as to who's going to get what.
But it does potentially limit what you can do subsequently. We've had,
which is the intent.
We've had clients who have falling out with family members and maybe don't want to include them in the financial, in the estate plan.
Right.
So you don't have that option.
You do in that if mom and dad are still alive and they both agree, you can amend the contract.
Yeah.
You change
usually this seems to happen when one of them is not alive.
Right.
And, something.
Right. And that in that case, what we're trying to do is make sure that the wishes of the first to die remain honored.
I'm thinking of an example where second marriage, the children didn't like stepmom.
Yep.
Weren't particularly nice to stepmom.
Right.
Stepmom had originally kept the everyone in the IRA.
Right.
But over time, because there was his IRA and her IRA, which now are both hers,
Right.
But over time, things changed and hey, they've lost touch. They're not ever involved. Was this kind of mindset evolving that changed over time.
So the way we handle that,
they've been basically written out over time.
The way we handle that with the contract to will or contract to plan is to basically say, if it's a second marriage, and the percentages will vary depending on the client's need, but my half goes to my kids, your half goes to your kids, and you just promise that you're not going to take my half away from my kids.
Yeah.
So, in other words, that in that situation, the widow could say, well, fine, you're going to get your dad's stuff, but you're not getting my stuff.
Right.
Yeah. But that's not what was going on here.
Yeah. Right.
Yeah,
Right.
exactly. We've just got a couple of minutes left. These issues can be complex, and some people have more streamlined, straightforward kind of estate,
Mhm.
and other people have more properties, more complexity, more family dynamics, whatever it
Right,
might
right.
be. And you mentioned this sort of trustee manual as one resource. You have combination of approaches that you work with clients, sometimes whether it's just they have a transaction to get the estate plan up and running and off to the races they go.
Right.
You also have programs where there's ongoing assistance and opportunity to adjust along the way. Talk a little bit about some of your structures.
So,
Am I right?
yeah. So, yeah, I mean, we've got a couple of things. So we've introduced a maintenance program where, for a relatively small amount of money, somebody can have a annual meeting that's included as a part of the maintenance program.
And some adjustments included with that?
Well, we give a 10% discount off of, flat fee services, or a 10% discount off our hourly services for families that are on the maintenance program.
A big part of the benefit of that, though, will probably be implementation. I got to imagine most people don't really implement the way they intend to, because things change. They sell that house, buy another house.
Right. And the house
always
doesn't go back into the trust where it belongs. Right.
Things
so
like
those
that,
kinds of things. So that's where the maintenance program can help, if they want help to make sure that, a review of, hey, is everything funded the right way? Those types of things are available for clients, and that we can look to see.
And it's nice for you in that instance to have the update of things move from account to account, or the values change over time.
Right.
So that
does
if
that introduce
happens,
new problems or new issues?
And if something happens, you are more current on sort of what's the landscape of the plan.
So, we're actually scheduling right now our annual walk through the trust and funding review seminars for our clients. We're going to be doing those in July and August. And it's just a good chance for our clients to come back in and kind of review get a translation of the legalese, review their trust and find out, what does all this mean? And during the course of that, we go over, well, what changes in the law have occurred? And so, if you last updated in 2011, well, you'll see that in 2012, we added this, we added that, we changed this paragraph, we brought in new techniques.
Jeff's laughing because he's like, I'm sure it's immense, the changes in the law. Is that what you're snickering at?
I am. There's been a lot of changes in the probate world.
Yeah. So, I mean, it's a good opportunity for people to get a freshen up on that. And I've toyed with doing that as a public seminar as well. The problem is the structure of my trust might be different than the structure of somebody else's trust. Point. But to know,
well, just before we move on to that, over the next couple of weeks, you do still have maybe one or two.
We got two public seminars left. There's something on our website that talks about those, or you can call the office to get information.
So this coming week, there's, I think, 2 or 3. I've forgotten two that seminars. If you haven't had a chance to hear Keats and his team give a presentation on estate planning, it's an educational program, very easy to appreciate that there's complexity that you hadn't always considered.
Right.
When it's an opportunity to sort of get educated, learn the lingo, and not necessarily have to be committed, but it can give you a chance to see, oh, maybe this is a firm I could talk to or not. If it's a good fit for you.
Right. And for some reason you're not available next week, I think it's Tuesday and Wednesday are our remaining dates. If those dates don't work for you, we do have one available online on our website, boydandboydpc.com. There's a seminars tab. It's not the same content that we're currently giving, but it gives
close enough.
It gives enough that you get a lot of the benefit from it. So, feel free to check out our website and go to the seminars tab.
So let's remind everyone, so if you want to check out the, if you're listening to this conversation and thinking, gee, maybe I should review my estate plan, the website, Keats.
boydandboydpc.com. So it's BOYDAND, Look for the seminars tab, and you'll find there's about 5 different seminars that you can watch on demand.
Okay. Very good. So you were saying, though, like I got you off track because you were saying you have a couple of things going on.
We're going to do the client only seminars, the walk through the trust, walk through an IRA trust, and the funding review,
and the maintenance program has some of the
and actually that is, we're offering a special right now for people who sign up for our maintenance program, they'll actually get a 10% discount on any estate planning services that we provide to them. So if they want to do an update, they get a 10% discount on the update. That's only good through the end of the month.
Great. Okay. Right. So, and then, when you have some of these different programs for people to get up to date, and then you have the, sort of the basics that we were kind of saying is coming up. You have only a couple more before you take a break, and then you do it in the fall, maybe.
Yeah.
But in addition to that, if someone's listening, maybe they could have a consultation if they don't get to come in. For
absolutely. Yeah. I'd still urge people to listen to our online seminar, and then, would love to meet with anyone who's interested to talk about how we can help them with their estate plan. We give a free consultation, about an hour. And there's usually a lot we can do. I just, if we have time, there was something we're talking about in our current seminar that shows the value of the planning that we do. And we're finding that so many people now can get pretty close to the $1 million number that's out there, for estate taxes currently. Might change before the end of the month. But, if a client who has $1 million estate, the type of planning that we typically put in place for them over their lifetime, their children's lifetime, maybe the grandchildren's lifetime, can have a tax savings up in the neighborhood of almost $4 million. So we're creating wealth, we're preserving that wealth, and we're trying to reduce the taxes that are incurred. We're trying to basically,
the compounding effect over
generations. You look at an IRA. Why do you put your money into an IRA or 401k? It's the power of tax deferral, right? Well, your trust can be built with the power of tax deferral, effectively doing the same kind of a thing to create more wealth for your family.
Preventing tax or avoiding tax.
Exactly. Exactly.
Thanks for coming in. We'll have to have you back sooner than the last time.
Okay. Sounds good.
Lots to talk about.